Hi everyone, welcome to part 16 of the revision lecture series on arbitration. In the previous video, we have already looked at the disadvantages, that is the major disadvantages of getting engaged in litigation proceedings. And in this video, we're going to consider some of the advantages, that is some of the benefits of choosing ADR processes, and later on in this video, we're going to look at some of the advantages of choosing arbitration, that is one of the forms of ADR in particular. So obviously there are many benefits of choosing ADR processes instead of litigation proceedings. However, in this video, I'm going to first focus on 4 major advantages, that is 4 major benefits. And once again, the reason is that under exam pressure and time constraints, it's not always possible to write everything under the sun, even though you may know about that topic in detail. However, it's best to have a few structured bullet points in mind that are going to be easy for you to recall. Okay, so without further ado, let's look at the 5 major benefits of ADR. And remember that the 5th benefit relates to arbitration in particular and not to ADR in general. And at the end of this video, I'm also going to talk a little bit about some other benefits, and those may not be that important for you. Like I said, I leave it up to you to decide how many points you want to include in your exam essay. Okay, so first and foremost, let's talk about efficiency, because ADR processes are in general way more efficient than litigation processes, and as we all know, efficiency guides our choices in all areas of life. So why not choose efficiency as the guiding criteria when deciding how to solve a dispute that has arisen between you and another party? So remember that the key benefit of choosing ADR processes over litigation is efficiency, and in particular, businesses would rather spend their time on growing and promoting their businesses rather than in courtrooms. And of course, in contrast to what we studied in the previous video as regards litigation, in contrast to litigation, ADR processes are much faster and cheaper. And of course, once again, the global trend these days currently is that we want everything much faster and much cheaper. And arbitration in particular, as compared to court adjudication or litigation, is definitely less expensive. In particular, in arbitration, the arbitrator's award is not open to review or appeal, unless of course there is some sort of error on the face of the award, and we're going to discuss this later on in another video. For now, just remember that this fact means that not only is precious time saved by removing the possibility of unnecessary delay, but also that this provides certainty, which is so very crucial in the business world. Okay, so the third advantage of ADR processes, and in particular arbitration, is that arbitration is procedurally less formal than court adjudication, and arbitrators are not bound by the strict rules that the regular court is bound by. So remember that the other 3 forms of ADR that we talked about, that is negotiation, mediation, and conciliation, those are essentially non-adjudicative processes, and arbitration, which is the 4th ADR process, even though it is an adjudicative process, but despite that, it is definitely much less formal, that is, it involves much less formalities than the adjudication processes of the court. As a result of this, arbitration proceedings are usually much shorter than court proceedings. Number 5, that is the 5th advantage that we're going to be looking at, applies particularly to arbitration proceedings and not to other ADR processes, because we're talking about the fact that arbitration proceedings produce binding results, whereas of course the other ADR processes don't always do so. So when you mention this benefit, keep in mind that at this moment we're not comparing litigation to other forms of ADR, but instead we are mentioning one particular advantage of arbitration as compared to the other forms of ADR, and why arbitration is more effective, that is, since it produces binding solutions. So in short, the other forms of ADR, as we've seen in the previous videos, are not binding, and that means that even if an agreement or compromise is arrived at eventually, the parties may not be legally bound by the decision produced as a result of those agreements. Okay, now the fifth point that I'm going to discuss is expertise, and this advantage is the major advantage in my opinion. Why? Because it's very important to remember that the choice of forum, that is the choice of a judge, is something like we've seen in the previous video that is not left for the parties to decide. And in arbitration proceedings, the parties, on the other hand, by the way, this applies for other ADR processes too. That is, the parties are able to choose who should hear the case, and taking expertise and experience into account. So if the involvement of specialists or experts is crucial in a certain case, then the arbitrator may be selected accordingly by the parties. In fact, if a case turns largely on a specialist matter requiring expert evidence, then it may be more appropriate to avoid litigation proceedings and to focus on determination by an expert in the field. So, just to mention one example, if it is a matter relating to, for instance, construction, then an engineer may be considered as the expert in that field, and if the matter relates to some sort of health issue, then perhaps a doctor, a qualified person who has the expertise and the relevant knowledge in that field, may be the best person to decide the dispute. And well, of course, even in a court proceeding, it is possible to involve a specialist where expert evidence is required to decide the matter. However, in a court proceeding, the judge is not always an expert, so this means that an expert will have to be hired eventually anyways, and that means additional costs for the parties anyways. So I guess it's best if you just choose arbitration proceedings, since in arbitration proceedings, the parties can themselves agree on choosing somebody as the arbitrator who is already an expert in the field. Right, so that's it about the major advantages of choosing ADR processes, and in particular arbitration, as opposed to getting engaged in litigation proceedings. And as promised at the beginning of this video, that towards the end of the video I'm going to be mentioning some other points that may be useful to you for the purposes of your essay, depending on the requirements of your particular syllabus. So one additional advantage that you may want to know about is that ADR offers control of process. So once proceedings have been issued in a court, then a court case is essentially under the control of the judge. However, in ADR processes, there is more of client autonomy, and clients therefore usually have a greater control over the process as a whole. And in addition to control of process, when a dispute is resolved through some form of ADR, then a wider range of issues may be considered. So in litigation, what happens is that sometimes when a client presents the lawyer with issues, then for the lawyer, it's not always that easy to categorize those issues in legal terms. So sometimes what happens is that the issues are so complex that it's not possible to categorize them in the definite legal terms as is required in a legal case. So such issues that may be difficult to solve, because it is very difficult to phrase them in strict legal terminology, then ADR may be a better alternative. And in addition to these, of course, there are many other advantages, and I'm not going to be discussing those in detail. However, I'll just mention them briefly in case you are interested. So among the other advantages, that is the possible advantages or benefits of ADR processes, are first of all client satisfaction. Second, there is the possible reduction of risk. Third, there is a use of a problem-solving approach in ADR processes, which is not seen usually in litigation proceedings. Third, ADR processes as compared do public litigation proceedings obviously offer greater confidentiality? Fourth, while we've already mentioned the flexibility of process and lesser formalities, but also that there is flexibility with regard to evidence. And finally, the fifth point is, as already mentioned, not only may a wider range of issues be considered, but also a wider range of potential outcomes is possible in ADR processes than in litigation proceedings which take place in court. So at the end of this video, I'd like to mention that in light of all of these advantages, that is so many benefits that we've just considered, it is not at all surprising why the use of ADR processes has grown globally so much in the recent years.